Hey guys, Anthony Bandiero here, attorney, senior legal instructor for Blue to Gold. Bringing the roadside chat from an officer in hold on, let me make sure I got my Dakotas correct. South Dakota. Okay, I was close. So the officer is asking, hey, if I want to interview a suspect that is in jail for another crime, but I want to interview them about a different crime, do I have to read them Miranda? The cop has heard it both ways. This issue is not crystal clear. There are some cases out there kind of give us some guidance. But let me give you what I think the answer is. The answer is probably not. You don't have to give them a Miranda. And here's why. Now, Miranda is required under three conditions, right? One, the person is in arrest-like custody, right? Arrest-like custody. Number two, they're being interrogated. They're being asked questions, which is reasonably likely, or it's foreseeable, that it will elicit an incriminating response. The person will tell you something that could actually hurt them in court. And number three, the person is talking to a known officer, right? They know they're talking to a police officer, not like an undercover agent and so forth. Now, you could have some Sixth Amendment rules come into play, but we're not talking about that here. So the main issue out of those three is going to be whether or not being in jail qualifies as arrest-like custody, and the answer is probably not. And the why is because even though they're not free to leave, and they're in a jail, and they can't leave, they're not free to leave. The reality is that is their home, right? That is their home temporarily. That's where they sleep, where they eat, and so forth. The U.S. Supreme Court has held the same logic applies to prisons, right? When a person is in prison, they're not in custody for Miranda purposes, as long as the level of confinement is consistent with their routine. So if they are normally shackled when they're taken from general population to interview rooms, and that is done during the interview process, for the interview process, then that level of confinement is consistent with their routine. Same with keeping handcuffs on them, right? During the interview. If they're normally required to have handcuffs on, and that's part of the jail policy, then it should not be a factor, it should not change the outcome. However, if the jail does not normally keep them handcuffed and it's optional, and the detective says, yeah, keep them in handcuffs during the interview, that's going to hurt this factor. The court may find that this was arrest-like custody, right? Just a level of intimidation, a level of coercion above the normal routine. So that's the issue here. And, so we have, interrogation, we're asking questions that can incriminate the person, and we have a known officer. So those two factors are in play, but it's that custody issue. At the same time, if cops are unsure, they should read Miranda, because, it will help you more than hurt, right? To actually read Miranda if you get a valid waiver. The other issue, since we're on this topic, that may come up is, don't forget that if they have invoked Miranda on a different case, right? If they invoke their right to remain silent, then you're not really supposed to talk to them about a different crime unless there's been a cooling off period, right? Or if you, as the Supreme Court said, you scrupulously honored their right to remain silent. So, if they just got booked in for a crime at 1 p.m. and they said, I do not want to talk about that crime, they invoked their right to remain silent. Cops coming in at 2 p.m. about a totally different crime are playing with fire, because you're not supposed to talk to them about any crime unless a proper cooling off period has elapsed. In one case, it was 2 hours. In other cases, courts want to see overnight. But the other issue, since we're on the topic, is if they invoke the right for an attorney. So if they properly, that's another topic for discussion. If they properly invoke their right to counsel on a crime, they are off limits for any crime for 14 days. And that may be a problem here, right? So if the guy gets booked in for, let's say, a misdemeanor warrant, but he's also the suspect for a burglary, and during the shoplifting or the misdemeanor warrant booking or interview process, let's say they want to interview him about something, or on scene, they read him his Miranda rights, and he says, you know what, I want an attorney. He's off limits for 14 days about any crime that has occurred up to that point. Now, if he has committed a new crime after invoking his Miranda rights, most courts will allow that to allow you to talk to him. That's very typical with jailhouse crimes, right? While incarcerated, he commits a battery and corrections officers want to talk to him about that battery and he makes incriminating responses. Most courts are going to allow that to come in, right? Because it's not previous. Kind of confusing, huh? I actually have a whole class about interview and interrogation, and it can be very, very complicated. So there's your answer. Basically in a nutshell, even though he's in jail, does not automatically mean he is in arrest-like custody for Miranda purposes. You have to look at the overall condition. However, best practice, read Miranda. All right? All right. Guys, before you leave, hit the like button, subscribe and comment below, share with your friends. And until next time, stay safe and keep up that great job that you're doing.
When it comes to law enforcement training, we are the gold standard. Visit bluetogold.com or call 888-579-7796 to learn more about our training, books, and free webinars. Also, don't forget to like, subscribe, and share this channel.